Well, welcome, everybody. I'm David Levy, and this is a Bolch Institute meeting or event, and we're so happy to have Jeff Sutton here. He's written a book called 51 Imperfect Solutions. There's been a bit of debate about what that 51st number is, but he'll clarify that, I'm sure. And to talk about all these imperfect solutions, we have absolutely the perfect panel here. And before we begin, I want to acknowledge that Mark Martin, who is the Chief Justice of North Carolina, is here. And our very distinguished colleague, Walter Dellinger, who was the Solicitor General during the Clinton administration. So this is a great book. What we're going to do, we'll just go right into it. So Jeff Sutton is on the Sixth Circuit and a very distinguished judge. And next to him is a colleague, Joan Larsen, who was also on the Sixth Circuit. And before she with Chambers in Detroit, but before she went on the Sixth Circuit, she was on the Michigan Supreme Court. And then to my left here is Allison, who's on the 10th Circuit with Chambers in Denver. And before she went on the 10th Circuit, she was a state Supreme Court justice in Colorado. And then to my left, far left, is Goodwin, most distinguished Supreme Court judge on the California Supreme Court. Goodwin was a law professor at UC Berkeley. Allison was a law professor at the University of Colorado. And Joan was a law professor at the University of Michigan. And yet they're here to talk about a book written by a guy who is not an academic. And
Most definitely not. Most
Pretty
definitely
impressive, but very daring. Okay, take it away.
Well, first of all, thank you, David. Thank you to the Bolch Institute. Thank you to Duke. When you write a book, you learn who your friends are. So thank you, friends. I really appreciate this. And I'm really thrilled to be here with my friends, Joan, Allison, and Goodwin. So why write a book on state constitutions? Well, if you were to go to the Duke Law Library and pull all the books on, quote, constitutional law off the shelf, or go to the class taught here on con law, you would see that it teaches and tells half the story. The focus in con law books in America circa 2018 is on the US Supreme Court and the US Constitution, rarely mentioning, if mentioning at all, the state constitutions or state courts. That seemed like a gap worth filling. The second reason for writing the book was that our stories, the stories we tell ourselves about con law usually follow this narrative. And in fact, for the students, this is really all you need to know to pass the bar exam on the federal con law questions. States, villains, good guys, US Supreme Court. If you got that right, you're going to get every answer correct, because that is the basic narrative in federal constitutional law. Now, sadly, in American history, there's quite a bit of support for that narrative. The chapter Jim Crow being the best example, being brought to an end happily by Brown versus Board of Education, the US Supreme Court decision. So I didn't set out to contradict that narrative. I did think it might be worth supplementing that narrative with stories in which state courts either were the heroes. There's one story, Buck versus Bell, where the heroes are clearly the state courts, the villain, the US Supreme Court. And some other stories where it's actually really complicated as to who the hero and who the villain is, and it's really not even appropriate to think about it that way. It's really appropriate to think about it as a dialogue between state and federal courts as they slowly make their way to a settling of the issue, if a settling is how it's going to end. The third reason for writing the book gets to the federal judge side of me. I'm very nervous about the path the US Supreme Court is on in this country. I graduated from law school in 1990. As I've watched the Supreme Court, both as a practitioner, a law clerk, and now a junior varsity appellate judge, I've seen a court that's basically is in a rights escalation mode. You get your rights, we get our rights. Blue rights here, red rights there, escalation up, up, up. Now, in one sense, as a federal judge, I should love that path, and I should want us to stay on it. Why? Because it means we federal judges are exercising more power. If you have a government job, more power is usually better than less power. So I should love the path we're on. I should want us to stay on it. But for one small, minor problem, it's getting very hard for we Americans to decide who should be on that all-powerful US Supreme Court. Unless you've been hiding under a rock the last few years, and especially the last few months, you might have noticed that Americans care intensely about who is on this U.S. Supreme Court, as well they should. That court is exercising an awful lot of power over our lives, and I think it's actually quite reasonable for them to behave the way they have been behaving in making these decisions about who is on that court. So what I'm quite worried about with the path we're on at the federal level is that it will end in tears. It will end either with the American people not respecting this great treasure of American government, or are being unwilling to fill the seats on the court, putting them in a position where they really can't do their job. So how do you get off of that path? Path A, I'll call it. Path B is some kind of détente, some kind of situation where the court is not basically running too many of the issues in American society. How do you get people to engage in a détente, since we Americans live in a country that probably is the country in world history that believes the most in judicially enforceable rights and prizes those rights the most? It's a very hard path for us to get off of. Well, my idea, perhaps dreamy, maybe even delusional, is that we can look to the 50 state courts, the 50 state constitutions, as another way of thinking about what our individual liberties, property rights happen to be. Now, one oddity about American constitutional law circa 2018 is we started the whole thing in the reverse. All of our constitutional guarantees, the rights guarantees, originated in the state constitutions. Indeed, the greatest era of constitution writing in this country, indeed in the world, according to Gordon Wood, is between 1776 and before the fabled summer of 1787 in Philadelphia. The Philadelphia Convention was a cut and paste job. And same thing with the Bill of Rights. They were cutting and pasting from the rights that were already been adopted in the state constitution, authored there, and picking which ones to choose from, which language to use for the federal constitution. How ironic that we live in a world where all we think about, obsess about, is the U.S. Constitution's individual rights and the U.S. Supreme Court's interpretation of them, when they all originated in state constitutions and remain separately, independently enforceable by state high courts. So the point is, we've got 51 high courts, including the U.S. Supreme Court, 51 sets of constitutions. My last point here, before I turn it over to my colleagues, is it's very hard in this day and age to find agreement about a political science policy point in America. But I'm pretty confident we could get everyone in the Duke Law School together and get agreement on this one insight. And it's the Brandeis insight about the greatest virtue of American federalism. And that virtue is that a brave state can deal with a new problem with this experiment or that experiment, and we have 50 laboratories of experimentation, policy-making experimentation, through those state labs. You can have trial and error here, trial and error there. The results come in, another state can adopt what's been done. Maybe we end up with several regional approaches, or maybe after all the evidence comes in, we nationalize one approach to the issue. Now, what Brandeis was referring to in terms of policy-making labs was state legislatures as the policy-making incubators. The whole premise of the book, and all I am saying today, can be reduced to one central point. If we can all agree that that makes perfect sense with legislative policy-making, why in the world are we not doing exactly the same thing by treating the state high courts as laboratories of constitutional interpretation? Since every one of the guarantees we care so much about, we fight so intensely about, is protected in one way or another in these 50 state constitutions. Why aren't we doing the exact same approach with constitutional interpretation that we do with run-of-the-mill policymaking? Let the state courts, using state constitutions, be the first responders. If regional differentiation happens, all for the better. That's called a free market of ideas. The U.S. Supreme Court can watch that experiment unfold. Sometimes it will decide to nationalize one approach to the issue. Sometimes it will not. Sometimes it will decide to say we're going to allow some regional disparities to persist because we either think the U.S. Constitution doesn't speak to it or because there really isn't one good answer. And that's the point of the title. Why are we insisting so often on picking one imperfect solution to individual rights in a world in which we have the option of 51 imperfect solutions. If you got 51 imperfect solutions, a bunch of imperfect solutions, it makes very little sense from my perspective to pick one of them, nationalize it, make everybody live under it, whether it really is the best idea or, for that matter, a perfect idea.
So that's a great way to start. Can everybody hear? Can you hear? It might, if the control room is listening, maybe just dial it up a little bit.
Or look toward David.
Or look toward me. I'm reading my lips. Before we turn it over, could you just take a moment to talk about the structure of the book and the 4 areas that you focus on?
Yeah. So thank you again. When you write a book, you need friends. I have a friend.
We have the book, by the way, and it'll be available afterwards.
So there are 4 chapters. There are 4 substantive chapters, and one is the Buck versus Bell story. You all know that story. 3 generations of imbeciles are enough. It's arguably the most infamous U.S. Supreme Court decision, surprisingly still good law. The part of that story no one knows is that the state courts invalidated several state eugenics laws. Many of them use state constitutions to do that. Of course, that's not a story that's told. That's not a story that's in the literature. So it really is a story where the villain is the U.S. Supreme Court. The heroes of that story are state courts, state constitutions, and state legislatures. Another story that's a little more complicated, but everyone understands, is the school's funding story. In 1973, in a case called Rodriguez, it's March of 73, it's 2 months after Roe. This is a U.S. Supreme Court still willing to innovate with new constitutional rights. Still, in a case with some very serious equities, the court decides not to use the 14th Amendment's Equal Protection Clause to do some equalizing between rich and poor school districts. The stakes of that case could not have been higher. It really is the bookend case to Brown. Brown gets rid of racial barriers to a decent public education. At issue in Rodriguez fundamentally is whether we are going to get rid of wealth-based barriers to a good public education. The U.S. Supreme Court says no in a 5-4 decision. And what's fascinating is since 1973, 2/3 to 3/4 of the states have used their state constitutions to try to equalize the educational opportunities between and among rich and poor school districts in their states. And part of that story, I would say, is also a state legislative story. Another story is the Mapp versus Ohio story. The very provocative question there is whether criminal defendants lost by winning Mapp. That's a very provocative point. It's an unprovable point, as the chapter reveals, but it shows how complicated it is when the U.S. Supreme Court has to make a decision whether to nationalize a right. It usually takes with it state courts construing their state constitutions, and sometimes that baseline, which gets good for criminal defendants in Mapp versus Ohio, can go down over time, and unfortunately, state courts often follow that downward path. The key thing is Mapp takes over control of the issue, and the question is whether that was really good for the cause of criminal procedure, criminal liberty protections. The last chapter is about the Barnett-Gobaitis story, the compelled flag salute case. And the part of that story that I think shows how complicated this really is the message from that story is that, frankly, the federal judges and the state court judges fell on the job. Neither one performed very well, whether it's Gobaitis at the U.S. Supreme Court or the state court, state constitutional decisions during that early era. Happily, even before Barnett, you get several brave state court judges using their state constitutions to protect the rights of Jehovah's Witnesses not to have to salute the flag in violation of their faith. So those are the 4 chapters, and then at the end I've got a little bit of stuff that pulls in what I see as the federal U.S. Supreme Court problem, which is fundamentally we're just asking too much of them. I frankly don't blame the U.S. Supreme Court for what it's worth. And by the way, if you're listening, I report to you. I'm not blaming you. In all truth, I blame us. This is our fault. We are the ones that keep wanting them to nationalize these victories and shockingly get so resentful when we sometimes lose. You're not going to win them all. If you want to go down the road of the U.S. Supreme Court running the country when it comes to rights, you're going to win some and you're going to lose some. That is the way it's going to be. And I'm not sure that winner-take-all high-stakes approach is really what is good for us or good for the country.
You put a lot of themes on the table. It's really great. Good one.
Well, great. Thank you so much, David, it's a pleasure to be here with you and Judge Larsen, Judge Eid, and of course, Jeff. I've known Jeff for a number of years, been a long admirer. I was telling a non-law friend of mine that I was going to be at Duke to do a panel with Jeff Sutton, and my friend said, oh, didn't he just get sacked as Attorney General the other day? No, the guy I'm talking about has life tenure, at least during times of good behavior, so I cleared that up. Jeff has written a great book, and those of you who haven't had a chance to read it yet should definitely read it. What I want to do is make some comments that kind of situate his book within the kind of discussion about judicial federalism more broadly, and then sort of extend his thesis even more with a little vignette about Jim Crow and Brown. So the genre of federal judges writing about state constitutions is a pretty limited genre, but he has very good company, because many of you know that Justice William Brennan in 1977 wrote a very seminal article, one of the most cited law review articles of all time, only 16 pages long, by the way. Those of you who are law review editors, take note. That argued that was really a call for state courts to step up, to make individual rights decisions independently under their own state constitutions in the face of what Justice Brennan saw as a retreat by the post-Warren court on many issues of individual rights. And so this article definitely had, you might say, a valence to it. Brennan was a judicial liberal, and he was trying to maximize, in a sense, individual rights protections, and this was his sort of strategy for doing so. And the article, cites some three dozen or so U.S. Supreme Court opinions in which he dissented, and he said, state courts should look anew at these issues under their state constitutions. And by the way, I wrote dissents in all of them. So Jeff's book, Jeff is not someone who you would describe as a judicial liberal, not in the Brennan sense, or not in any sense. And so what is his book doing then in the same kind of shelf, in a sense, as the Brennan thesis? Well, here I think it's important to see the ways in which what Jeff is talking about sort of extends and complicates the picture that Brennan left with us. So Brennan was sort of thinking about state constitutionalism as a second best corrective, right, for mistakes, in his view, made by the US Supreme Court. But in Brennan's ideal world, the US Supreme Court would have gotten all this right to begin with, and the states are really, in his view, kind of like backfilling where the US Supreme Court has fallen down. Jeff has a very different conception, which I think is a very more historically accurate conception. And that is that, first of all, he questions the basic thesis about where, if you are an individual rights maximalist, and by the way, you could be liberal or conservative on that, doesn't really matter, but where would you go to maximize your individual rights? And I think his chapters on school funding and on the exclusionary rule are very provocative in that respect, because he asks the question, are we really better off, in the MAP context, the exclusionary rule, that the US Supreme Court has stepped in so heavily in micromanaging, in a sense, every aspect of police behavior instead of leaving some of that up to the states. And in the school funding context, asking, was the Supreme Court not correct to leave that issue up to the states, and did we get more out of the Supreme Court doing less? The second thing is that even in areas where the US Supreme Court ultimately will decide the issue, state constitutionalism is a way of pacing doctrinal change. So it's not that rights advocates should simply, as often said in the movies, take your case all the way up to the Supreme Court. That is sometimes too much too soon. And there is a kind of percolation that is necessary of arguments and experiences through the federal system that can inform, ultimately, a rights decision by the US Supreme Court. And so state constitutions and state courts serve that function as well. And the third thing I think that really comes out in the book is that this is not, as Justice Brennan imagined it, a politically liberal device. So we can talk about all the usual individual rights guarantees that Brennan wanted to talk about, But we can also talk about things like gun rights. We can talk about the reaction to Kilo. We can talk about the more stringent scrutiny that some state courts have given to economic due process rights. There are all kinds of ways in which the valence of that issue can skew more conservative, more liberal, and it need not be one or the other. And so I think Jeff provides a kind of nice balance to help us see the ways in which this is really a structural feature of our constitutional system rather than just, as Brennan imagined it, a one-way liberal ratchet. Okay, so I think that has been a very significant contribution to our understanding about judicial federalism. I want to just say a word now about state constitutions and get into the, open up a topic for more of us to discuss about how state constitutions are supposed to be read. Now that we say that there ought to be some kind of state constitutionalism, how should it be done? In order to understand this, I think you have to understand the nature of state constitutions, which I've come to understand a whole lot better in my current role. I think of state constitutions as having kind of four types, at least four types of provisions in them. State constitutions, many of them, most of them, are quite lengthy. And they're larded, in a sense, with many provisions that are, as one observer has called it, really just legislation dressed in constitutional garb. So these are not the sort of high vision structure of government and individual rights guarantees. These are things like, and I'll read to you a couple of them, these are things like Alabama's Amendment 492, Section 1, which promotes the sale of catfish. They are, the one I like the most is Florida Constitution, Article 10, Section 21, titled, I kid you not, limiting cruel and inhumane confinement of pigs during pregnancy. So we see stuff like that in state constitutions, and they do get stature in the sense that in the hierarchy of laws, they are the highest law, and so you have to apply them in the usual way. But that's not what we really think about. When John Marshall was saying it's a constitution we're expounding, he wasn't talking about pigs during pregnancy. So the second type of provision that you might find in state constitutions are really sort of rights or structure provisions that are specific to the state. And by this, I'll give you a couple examples. California, for example, in our Constitution, has an express privacy provision. Among the inalienable rights enumerated in our Constitution is privacy. And that's just a different thing than the federal Constitution, and there is doctrine built on that language in the state Constitution. Another feature is that in California, we don't have a unitary executive. We have elected offices for Attorney General, separate from that of governor, as well as other executive functions. And so this, so we live with that sort of constitutional structure. In those areas, of course, state courts need to be attentive to the particular state texts and histories that define these very state-specific provisions. A third kind are provisions that are similarly worded to federal guarantees, but despite their similar wording, have very distinctive state history. So one example of this would be the jury trial guarantee. Sixth Amendment has a jury trial guarantee. We're all familiar with it. Supreme Court in Duncan versus Louisiana in 1968 held that that jury trial guarantee does not extend to petty offenses, many misdemeanors, petty offenses. The Maine Supreme Court in 1974 said that the very similarly worded jury trial guarantee in the Maine Constitution does extend to petty offenses, and did a very elaborate job of tracing the particular history of that provision as it existed in Massachusetts, which used to encompass Maine, and showed that despite the federal cutting and pasting of that provision, the original provision that it adopted did apply to petty offenses. So you sometimes get some of those. But the fourth category is the one that I'm most interested in, which are those provisions of state constitutions that tend to mirror the federal and don't have any particular state-specific meaning. And actually, the balance of Jeff's book, most of it, concerns provisions of this type, where state and federal courts are essentially construing the same thing, the same, if not the exact same language, the same constitutional concept. And why, you might ask, does our constitutional structure contemplate this kind of redundancy, right, in interpretive exercise? Why two bites at the same constitutional apple, in a sense? And I think that understanding this question is very central to understanding the role of state constitutionalism in our overall structure, because that really is, in my view, the way in which state and federal courts are brought into conversation about our most important rights, the most important rights we have. If state decisions were siloed by their specific history, they could be distinguished away. They wouldn't necessarily need to inform the federal Constitution, but it's precisely because in areas like, just take, to take some obvious examples, the same-sex marriage decisions, the Goodrich decision all the way up to Obergefell. The state and federal courts were largely talking about the same thing. There was, when our Supreme Court in California in 2008 issued its marriage decisions interpreting the California Equal Protection Clause, there wasn't an equal protection concept that was Californian. We were talking about the same equal protection concept that everyone is talking about, but we interpreted it differently. And that decision then informed others in the state courts and in the federal. I want to end with just one further illustration of this dynamic that I think Jeff's book illustrates so well. And it really takes on the one bugaboo that Jeff began with as to thinking about why it is that we so disfavor state courts and prefer the federal when it comes to individual rights protection. And that is the narrative of Jim Crow and the road to Brown. So I think many people who have read Plessy know that one of the principal authorities upon which Plessy relied, Plessy was a case about rail cars, you remember, but one of the principal authorities upon which relied was a Massachusetts High Court decision called the Roberts decision, which was a school segregation decision upholding the separate but equal standard. It was written by Chief Justice Lemuel Shaw, one of the greatest jurists of his time, and that cemented, in a way, the separate but equal principle. What is lesser known, however, is that despite Plessy and despite Roberts, between the period from about mid-1800s to 1900, there were several dozen state court decisions about school segregation, more than half of which granted relief to the black plaintiffs, largely on state constitutional or statutory grounds within the confines of Plessy. And then during the same period, there were about 10 reported federal decisions, 5 granted relief. So state courts did not fare badly during that period. And many of you in constitutional law from your textbooks will learn the progression of the road to Brown, starting with the higher education cases, one from Missouri, which led to another one in Oklahoma, then Texas, and the rest. What is lesser known is that prior to the Missouri decision, the very first NAACP victory in a higher education case occurred in the state of Maryland, one of the first cases Thurgood Marshall litigated in a case called Pearson versus Murray, in which the Maryland High Court ordered the integration of the University of Maryland Law School for having denied admission to a very qualified black plaintiff. The Pearson versus Murray decision was the central precedent that the US Supreme Court then relied on in the Missouri case in 1938, which then became the pillar of the Sweatt versus Painter and other cases that led to Brown. Last data point, Brown, you remember, was actually 4 consolidated cases, one from South Carolina, one from Virginia. Kansas, of course, was the lead case, Brown, and then one from Delaware. The Kansas, South Carolina, and Virginia cases all came from federal district courts. All 3 of those cases denied relief to the black plaintiffs, though finding that the schools were separate and unequal, deferred a remedy, or essentially ordered a remedy that was an equalization remedy, and said to the black plaintiffs, well, you'll have to wait and see. You'll have to wait for the facilities to kind of catch up. In the Delaware case, that case went to state court, and Chancellor Cullen Seitz at the trial court level visited the schools and rendered a holding that the schools were unequal and segregated, and that the segregation, the inequality could not be remedied immediately, and thus ordered the desegregation of the schools. And that decision was upheld by the Delaware Supreme Court. And so finally, in 1955, when the US Supreme Court rendered its disposition in the Brown cases, it reversed the 3 federal district courts and affirmed the 1 state high court. I think that alone should give us pause in thinking about who are the heroes and who are the villains in our conventional story about state courts and federal courts. And there's much more to say about that, but I'll stop right there.
So I will probably touch on a few themes that have already been touched on, but I'm going to make it a little more, maybe a little more practical. So one of the things that Judge Sutton talks about in his book is he sort of laments the fact that litigants don't take their 2 free throws, to use his example. You come up to the line, and you have 2 free throws, and you only take 1. Well, why would you do that? Any Duke fan should know that you shouldn't do that, especially if you're playing Michigan. But you should take both of your free throws, one being your shot at the federal constitutional bucket and the other being the shot at the state constitutional bucket. And he says, you know, if you ask any state judge, they will probably tell you that people often don't take the second shot. And from my experience, that is definitely true. If we got arguments based on the Michigan Constitution, aside from the provisions that were unique to Michigan, it would usually go something like, here are all my arguments about why I should win on the federal Constitution. Oh, and if you don't buy that, then just find that I win on the state Constitution, but with no reasoning about why the state Constitution might be different. So it's easy to sort of, blame the lawyers, I guess. But I think about this and I think, well, if I were a lawyer arguing a case, or if I were a judge and it had been seriously presented to me, what tools would I use to figure out how the Michigan Constitution differs? And there, I largely come up empty. Now, that's not always going to be the case. So in Michigan, we had a case, I wasn't on the court at the time, but we had a case a year before the Kelo decision called Hathcock. So without guidance from the US Supreme Court, the Michigan Supreme Court had to decide the meaning of public use under our takings clause. The Michigan Supreme Court decided that you could not tear down people's homes in order to put up a shopping mall, that was not a public use. The US Supreme Court, the year after that, cited the decision and said, you know, thanks for your advice, but we're not going to go that way. So sometimes it does work that there are tools that you can use to trace back what's the original meaning of public use. But often that won't be the case. So if you think about the traditional tools of constitutional interpretation, we talk about text, we talk about history, and we talk about precedent. Many of the texts, at least in the one category that Justice Liu talked about, the texts are going to be the same. So the federal Constitution borrowed those provisions from the pre-existing states, and then the new states borrowed those either from the federal Constitution or from their older state siblings. And if you're borrowing the exact language, there's a pretty good likelihood that you wanted the words to mean the same thing. Otherwise, why wouldn't you have used different words? So it is often the case, I think, that people meant the words to mean the same thing. Now, it could be that either the state courts or the federal courts at some point took the wrong path, right? They started to interpret those words that shared a common meaning the wrong way. And their state courts could be a corrective, but of course, only in one direction, right? So because of the supremacy clause, states can never guarantee fewer rights. They can only be more generous. But as Judge Sutton points out in his book, the whole reason for the US Supreme Court incorporating many of the federal Bill of Rights against the states was that the states were not sufficiently protective of individual rights. And so what is the likelihood that when you're a state judge and you're interpreting a provision that is worded the same as the federal Constitution, you had a history, but your history was probably underprotective of the right. That's why it was incorporated in the first place. And so the chances that when you have an identically worded provision, you're going to come up with something where the states can do something different than the federal government, seems to me like those chances are slim. Now, there will certainly be cases. I think Kelo is an example. The petty crime example that Justice Liu gave under the Sixth Amendment is an example. But I don't think there will be that many under the traditional tools of constitutional interpretation. Now, some of you in the room might be saying, well, I don't like those traditional tools. I'm not into text and I'm not into history. I'm not an originalist. I'm a living constitutionalist. And so there's a lot of space for judges to be more protective. And surely there is. But I also think we need to think a little bit about ways in which state constitutions differ from the federal Constitution in terms of the interpretive question. So two of the big pillars of living constitutionalism as a theory are that the federal Constitution is really, really old, and the federal Constitution is nearly impossible to amend. And given those two things, what we need is the judges to be able to make sure that the Constitution can keep up with an evolving society. Now, that is true with respect to some state constitutions. So I believe Massachusetts has the oldest constitution that is still operating in the world today. I think it was 1780, perhaps. But that's obviously not true of all of our states. We have two states that came into the Union in 1959. We also have states much more likely to go into convention. So Georgia was the 4th state admitted to the Union, but it also has, I believe, the newest constitution adopted in the 1980s. So states are much more likely, Michigan's constitution is from the middle of the 1960s. States are much more likely to convene in convention and update their constitution through democratic means. Many states, about half the states, also have the ability to amend their constitutions through direct democracy. And that's how you get to the pregnant pig provisions of the Georgia Constitution. And so if you have the ability to do things like that, to amend your constitution through the ballot process, which is not something you can obviously do with the federal, it makes me wonder whether state judges should think a little bit differently about their role than federal judges do, even those who ascribe to the living constitution mode. So those are my thoughts about the interpretive question, and I'll turn it over to Judge Ide.
Well, great. Well, thank you so much for having me here. I was going to say Dean Levy, former Dean Levy. And it's just been great to be with you all. This is such a great panel. And thank you all for coming. I can't believe how many people have turned out for a state constitutional law talk. So thank you for your interest. I just want to kind of take up where you left off, because Colorado is an initiative state. I don't know if any of you have been following. We have amended our Constitution maybe 150 plus times. We love state constitutional law in Colorado. And so we are really one of these super active states on the constitutional front. And I just want to start by really thanking Judge Sutton for bringing this topic to everybody's attention, because I do think it's very important being from Colorado. I also just want to say that has consequences for you all. I'm going to tell my cautionary tale here. I think Judge Sutton has heard this. I hired a wonderful intern. This person is not from Duke. But this person got an assignment to research something, write a memo, and came back and presented their 30-page memo to me. And I looked at it and thought, oh no, they didn't check the state constitution, which we had just passed a very lengthy constitutional amendment on this topic, and this person hadn't cited it at all. And so it changes the dynamic of how you do work. At least in Colorado, you've got to check the Constitution first. And I think that's exactly what you're talking about. There are things in the Constitution, Colorado Constitution, you wouldn't imagine, but you need to look at it in one of these very active constitutional states. My favorite provision, I don't think we have kids, but we do have a constitutional provision banning public funding for the 1976 Olympics. Because the state just did not want the Olympics to come. We didn't want people to move to Colorado or even see Colorado, because when you come, you stay, right? And so literally we have a provision banning funding for the 76 Olympics, and shockingly, the 76 Olympics did not come to Colorado, and we've not had them since. But I use that as an example just so you get a flavor of how many things are in the Constitution in Colorado and how robust a state constitutional conversation is in Colorado. So today, this book, and I think this, as you point out, is really focused on those provisions that are parallel, where you have a state constitutional provision and a federal counterpart in that discussion. But I just wanted to say, when you go to Colorado and you talk about state constitutional law, you're not talking about that. You're having a discussion today about what happened Tuesday with all of our constitutional ballot initiatives. So it's a different topic. All right, the second point, I think just picking up on Judge Larsen's point is, I'll start with chapter 7 of the book, which is entitled, What State Court Judges Can Do. And of course, I'm not gonna like that chapter as a former state court judge, right? And I think the book puts a lot of emphasis on what state court judges can do. And I push back a little bit on that, because I just have to say, we on a state court, I shouldn't say we anymore, but on my former gig, state court judges do exactly what federal court judges. You look at text and history, and I'll just read our standard from the Colorado Supreme Court in a case called Curious Theater Company versus the Department of Health. And I didn't write this case, but I was on the court, so at the time enjoyed it. And I'll just read this passage. This court is the final arbiter of the meaning of the Colorado Constitution. Oh, really? And as such, it is clearly within its power to determine that the state constitution places restrictions on legislative action even greater than those imposed by the federal constitution. And then we go on and say, we have, however, generally declined to construe the state constitution as imposing such greater restrictions in the absence of textual differences, some local circumstance, or historical justification. And that's, I read that just because that is the standard. It's a pretty high burden. The court goes on to say, you can't just come in and say the Supreme Court is wrong. You've got to come up with some reason, some justification for the Colorado Supreme Court to look at the state constitution differently than the federal constitution. And I just put that out there because that's the arguments you all, when you go out and practice, will have to make. And that's a burden. That's work that you all will have to do. As judges, we look at those arguments, but you all have to make them. We don't make the arguments just kind of sua sponte. So I just call that out. I read that. It's a tough burden, I think, to meet. So.
Great. Well, do you want to take a little time to address anything? I don't think you were wounded too terribly,
No.
but how are you feeling?
No, I mean,
No.
We love the book.
We love the book.
Yeah, everybody
We
loves
love
the book.
state courts.
Yeah.
We
I
love
just,
Jeff.
We can't just get up and
Yeah. No, I want to say.
I think
before you say
I should be a state
anything-
court judge.
You are.
I think you guys correctly left the state courts, and I should go to state court.
Yeah,
That's,
there
I
you
think
go.
what we should do.
You'd have to be elected.
That's all right. Have you not watched? I can do this. I am very good at persuading people to do what I want.
I want to say to Justice Liu that we're in North Carolina, so a provision about pigs in a state constitution is obviously important.
I thought it's the Charlotte's Web provision, right? You got to protect the pigs.
And has anybody read the Magna Carta recently? It is full of all kinds of interesting things. You'll be reading about how much cloth can be sold at this port and bought at this port, and who can sell cloth, and then it'll say, oh, you can't be convicted of a crime without the unanimous verdict of 12 jurors, and then it'll go back to protecting pigs in Alabama or something like that. So there's a tendency in these documents to kind of go back and forth. Yeah. You may have a few things you want to say.
Well, let me just say a couple really quick things, because I do want to hear from you guys. Questions are great, because then you know at least one person's listening. 15-minute assignment. Unenforceable, but it'll be worth it. Just read the state constitution of the state in which you plan to practice law. Don't read the whole thing. They're very long. Just go to the individual rights section. You will be blown away. I don't care what state it is. You will be blown away at how often the language varies. Different words, different interpretations. They are not monolithic. That is the assumption. Just read. There's no point talking about it. Just read it. This will hit you hard here in North Carolina, but it is true that American basketball players are smarter than American lawyers. Utah versus Strieff, very important Fourth Amendment case from a couple years ago. State prosecution. Strieff's lawyer, a very good lawyer, by the way, raised only the federal constitutional claim, actually won in the state Supreme Court. Tom Lee wrote the decision, 5-0 decision for Strieff, gets reversed at the US Supreme Court. Strieff now sits in jail because his lawyer did not know about the state constitutional guarantee. I can assure you, at least 3 members of that court would have ruled for Strieff on the state constitutional ground. The phrase is the same, unreasonable searches and seizures. Judge Larsen, Judge Ide might be right that a lot of states want to lockstep their way through life. They're free to do it. It's a big country. We have 50 states. We can have 2 lockstepping states if we want. As an Ohioan, I don't mind if Michigan's a lockstepping state. It diminishes them. But if you want to protect rights that the U.S. Supreme Court is under-enforced, you have no other option. This U.S. Supreme Court is not the Warren Court that Judge Larsen was referring to. The Warren Court, the one that identified, developed, muscularized all these rights. If you haven't noticed, there's not as much rights innovation. This is not a debate. This is a math problem. If the U.S. Supreme Court says no, there is one option left. All right, you're not going to amend the Constitution. You may try to change the composition of the court. That's a couple-decade process. You got one option left, the state guarantee. Read the history, you'll find something. A good lawyer, it's legal imagination, and one reason the lockstepping is not the state court's fault, it's the lawyer's fault, and it's the law school's fault. The law schools aren't teaching it, therefore there is no separate language of state constitutional law. It's like suddenly saying, let's all speak French when no one's ever had a French class. Can't be done. So you guys have got to figure it out, come up with a new language, and win the case. Strieff gets out of jail rather than sitting in jail. The stakes are that high.
Can I have just a moment? Which is to say that...
this is a sibling rivalry.
So the Fourth Amendment is always the easy one to go to, because the question is this unreasonable? It's a balancing test. Sure, people are going to balance differently. But it's not a hard constitutional line, like, I don't know, the right to jury trial.
How about this? We'll do state
Unreasonable.
We'll do state constitutionalism only in criminal law. How about that? That's half the cases. There are 84 million state court cases in a year, 350,000 federal cases in a year. Obviously, the stakes are higher in state courts. About half of those cases are criminal law. I'd be satisfied if every state court in the country just took seriously the criminal procedure protections in its state, including unreasonableness, which is balancing.
It's
We'd be in
balancing. I
agreement.
think people could
That's
come out
good.
differently.
Could I jump in?
Now you're getting nervous.
No. You're like, what
No,
are
he
we gonna-
can't. You're going to tell us you
It's a
can't.
tall order. Well, I think that Judge Ide's, the quote that she read from this case, Curious Theater, I think really encapsulates well what the nature of the challenge is. So I think what Judge Ide read is what I would think of as the dominant conventional view out there, which is that state courts adopt the posture that when they are construing an identically worded guarantee, they don't feel at ease, at least, even if they are free technically, but at ease, departing from a US Supreme Court decision that's on point unless they can find some textual difference, state-specific history, or some local circumstance, right, that justifies the departure. My personal view is that this is wrong. This is a wrong way to understand the federal structure. It's a wrong way to understand why it is we have state courts. And the reason this is wrong is that there are a number of historical reasons, which I think Judge Larsen and Judge Sutton both pointed to, which is that the provisions themselves in state constitutions were put there by people who wrote words that then informed the federal and then were genuflected back onto state. And so there's a porousness of these provisions that wouldn't necessarily grant to just one decision maker the one final word of these concepts. Forget about words, but they're encapsulating these concepts for all of America for all time. So just historically speaking, the states have as much ownership, in a sense. If you're originalist, they have as much ownership of the meaning of these words as the national court would. But more importantly, I think for present day purposes, just pragmatically, the notion that this sort of takes Jeff right where he began, which is that the idea that we would entrust one single court with the one right answer to all these problems, that too is antithetical to the basic postulate of federalism. So redundancy. We have lots of redundancies in our constitutional structure. In fact, they make things inefficient. That's kind of the problem sometimes in our constitutional structure. But that also is a way in which our structure provides channels for conflict, not necessarily in order to settle conflict for all time, but rather to manage it, to ensure that everybody, even the losing side of conflicts, continues to be part of the process, right? That could not be more important than it is now, it seems to me, in the way that we're going in this country. And so the idea that you have state courts that are disagreeing with what the federal court does doesn't strike me as at all an affront to the rule of law or undermining the objectivity of the constitutional decision-making process. Ordinary Americans know reasonableness. I mean, there's lots of, why do we even have 9 justices on the Supreme Court? If it were so clear what the answer to things are, why would we need 9 people to figure it out? So I'll just give you a couple examples of just this proposition. If you just think about, I already gave you the same-sex marriage example, but if you just think about, for example, Batson versus Kentucky, that's the case about peremptory strikes being unlawful when they are motivated by race. So in a case called Swain versus Alabama, some 10, 20 years prior to Batson, the court had said, you can't prove racial discrimination in jury selection on the basis of the strikes against the jurors in that particular case. There has to be a broader pattern. Well, guess what? A number of state courts disagreed, just flat out disagreed with that holding of the US Supreme Court, accumulation of those state court decisions under their state constitutions, not citing any particular state-specific factors or historical, idiosyncrasies or whatever, just disagreed. Then informed Batson versus Kentucky. So if you go to Batson versus Kentucky, you see the US Supreme Court citing these state court decisions under state law for the basic proposition that Batson then establishes. It's the same story with respect to New York Times versus Sullivan, the actual malice standard. You will see that decision, not coincidentally, was written by Justice Brennan. Cites about 10 state court decisions under state constitutional law to say that the actual malice standard is the correct standard under federal law. This cross-citation of these cases could not occur, in my view, if state courts were solely in the business of siloing their state decisions on the basis of state-specific considerations. Federal courts just could so easily say, we don't need to pay attention to that because the state court itself says we're different. And so it doesn't necessarily inform what the federal is. The reason it does inform is because the state and federal courts are engaged in a common interpretive enterprise, interpreting the same thing when that makes sense.
Yes, I just want to emphasize one thing that Goodwin said, which I think is really helps to think about this, I hope in a fair way. So when the U.S. Supreme Court uses state court decisions, obviously the U.S. Supreme Court justices that use them are probably going to be justices that adopt a similar method of interpretation, right? A state court originalist decision is going to be very appealing to a Scalia. A state court more living constitutionalist, norm-shifting decisions can be more appealing to, say, a Justice Brennan. Fine, this concept is for everybody. But let's keep in mind one other possibility. If the U.S. Supreme Court decision is, say, originalist, and the state court happens to be more living constitutionalist, of course they should not lockstep. That makes no sense, right? I mean, their method of interpretation denies the possibility of looking at it the same way the U.S. Supreme Court did it. And the opposite's true. If you have a living constitutionalist U.S. Supreme Court decision, you're now a state court judge getting the same issue under the state guarantee. It makes no sense that you would presume the U.S. Supreme Court's right. You should actually presume the opposite if you take the methods of interpretation seriously.
Okay, lots of points. All right, we have a little bit of time, and I mean a little bit of time for a question or two.
Sorry, you get 4 judges up here.
Yeah.
We're academics, and we just talk.
Walter, do you have a question?
Yeah, I'm wondering if there's support for Jeff's thesis, and particularly as the Judge Liu amplified it, in an argument that state courts have greater legitimacy than where we are now with the federal courts. That we are one justice away from this president naming someone who would be the 5th justice named by a president who came into office with fewer votes than his opponent. Now, President Bush was reelected, but you know, with the benefit of the politics around 9/11, so that we can have a majority of the Supreme Court with presidents who didn't get as many votes as their opponent. Now, I'm not saying it's not lawful, nor is confirmation unlawful just because we're moving into a period where 30% of the country is going to have 70 senators because the rural areas have gone in an ideological split. So we almost have the counter-majoritarian difficulty on steroids, coupled with the fact that it's a very old constitution. So the points you all are making, that first of all, state constitutions are more recent, more amendable, more susceptible, therefore, to popular input. And the notion that though it varies from state to state, you're chosen in different ways, but almost always in ways that are a little closer to popular majoritarianism than the way we're choosing federal judges. So I'm wondering if that's a legitimacy, a greater legitimacy argument.
Judge Sutton addresses this in the book, actually.
Yeah, I mean, I think it goes both ways. I mean, the first answer at most law schools would be you've identified a majoritarian difficulty, which is we can't take state constitutions and state courts seriously because they are so majoritarian, they can't be trusted to look after dissenters, minority rights. And so that has been a very central critique. I do think the other side of it is we now live in a world where they are the most accountable judges, because in most states there's some form of election, retention, and you know, at a minimum, perhaps that can justify a little more rights innovation when the people have a little more say over who those people are. I guess that's the way I might think about it. No one has done any research, to my knowledge, that says these differences have led to different forms of interpretation, which I think would be very interesting to see if that's happened.
Can I just say that having run statewide, I think I'm the only one who ran on a statewide, like, contested ballot, a nonpartisan ballot, but nonetheless, like, I had opponents. I mean, at least in Michigan, you don't campaign on, like, I'm going to vote for the unions every time. I'm going to vote for the, you know, for management every time. That is just not what we did. And so I just don't think this idea of we're going to be accountable for our results is the right way to think about it. I feel like that's always grading the judges on a test they didn't take. The test is, you know, I got up there and I said, look, if you're looking for a particular result, please don't give me any money. Please take it to the legislature. You know, what I have is, like, I have some legal training and I have some patience to sit through and read all these books, and I'm going to do that, and I'm going to work really hard for you. It's a really boring job, and So it's just a different, so I don't know about this idea that you're more accountable for your decision-making, but not at the end of the day for your results, or I wouldn't want it to be that we're running on our results. I think once judges start running on results, I don't know what the point is. Like, just let the legislature decide everything. Why do you need judges?
Well, what a tremendous panel. I think we'd be prepared to let the four of you pretty much to decide everything. Maybe not everything, certainly about pigs. And let's give them a big